Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I am super duper grateful for everything that you do. Please do check us out on those alternative places, Rumble and X. Those places don't censor me. However, YouTube often does. They either delete a video, which they don't do very often, they demonetize them all the time. And oddly enough, even when they demonetize them, they still run ads on them. I never figured that out. But they'll also just shadow ban the tar out of it. So if you want to support the channel, head over to Rumble or X and also follow over there. That would be super helpful. I've got an interview today with Chuck Michel from Michel & Associates. He's a constitutional attorney and has a great law firm. He's also the volunteer president of the California Rifle and Pistol Association. I wanted to chat with him about Rahimi, which is the case United States versus Rahimi that was just argued before the Supreme Court the other day. And it deals with Mr. Rahimi's constitutional right to have a gun, even though he was convicted of being a domestic abuser or accused of such. I don't know the whole details of that. But in any case, it's an interesting case and one that I think that has started to worry gun owners. Well, I'm going to tell you, I don't think there's anything to worry about, even though what you might read in the mainstream media would say otherwise. But let's go talk to Chuck and find out a bit more. Chuck, thank you very much for joining me. I'm very, very grateful. We got some really, you and I have talked about the Rahimi case before when we were anticipating the oral argument. And I know one of the concerns is obviously that the poor gent who was fighting for Rahimi is a public defender. So you folks, and along with a bunch of other people, were helping him out, trying to prepare him for the case and get him going. He didn't seem to do that bad, honestly, for a guy that's never gotten before the Supreme Court before. That's kind of intimidating. They asked him a lot of questions. And, I think he got lost a little bit and he was a little confusing, but he didn't do too bad. What did you think?
He was definitely mixing some things up, and got pretty roasted by a couple of the judges, even the friendly judges, for that. But look, this is a tough case with a unsympathetic defendant, and a bunch of judges who, as pro-Second Amendment as they may be, they are not going to try and give criminals a break. And this guy, in their view, he shoots at people and he doesn't deserve to have a gun individually, as an individual. But so let's remember what's the big context is here that Rahimi fits into. After Bruin, there's supposed to be a two-step test, not a test. I keep calling it's not a test. The government calls it a test. It's two questions. Second part is a test. The first part is just supposed to be, does the text of the Second Amendment, right to keep and bear, i.e. right to possess and carry a firearm, does the text of that Second Amendment apply to whatever conduct is being regulated? That's not supposed to be this convoluted test. It's just supposed to be a question. And if it's a bearable arm and somebody who is in the people is bearing it, that's the end of that question. Then the burden of proof shifts to the people, to the government, to show that there was some historical law, some analog law that would indicate that the modern day law would have been tolerated by the founders in 1791 or shortly thereafter. Now, what has happened is the governments, spoon-fed by lawyers with Bloomberg law, with Everytown Law, paid by Michael Bloomberg. These are big firm lawyers, very smart, very clever, and they have managed to convolute the test and move a lot of stuff into question one, which is not supposed to be there. So they have, for example, gotten into questions on whether or not magazines are arms, whether or not, in Seventh Circuit just said AR-15s are not arms. This is complete baloney. Every bearable arm is covered by the Second Amendment, and I think that even includes fully autos. That doesn't mean that they passed the second part of the test, but they're certainly covered by the plain language of the text of the Second Amendment. Then it's supposed to go, okay, what historical analogs are there? So yesterday in the argument, what we were looking for was an indication that the Supreme Court would clarify some of this stuff and stop some of the games that are being played, where they're switching the turning that first step into a test, whether or not the product or the conduct being regulated is a norm or not. In this case, you have there's three very basic types of laws: prohibited people, prohibited guns, prohibited places. This was a prohibited person test, and they're talking about the state's code section 922G8, I think, if I recall off the top of my head. Remember, there's 922 lists a number of different types of people that are not allowed to possess firearms, the classes of people. And that includes drug users, that includes misdemeanor crimes of domestic violence, that includes felons, that includes people subject to a restraining order. And that's what Mr. Rahimi was charged with, possessing a firearm, even though he was subject to a restraining order, which the terms of which called for him to not possess firearms. So that's the question that the court was trying to address. And in doing that, the interesting thing to me is, first of all, they defined this. The Supreme Court in some previous cases had said responsible and law-abiding citizens are people. They're the ones that are protected. And so if you're irresponsible, you might not be protected. But what does irresponsible means? And Judge Roberts dug in on that. He's like, well, I don't pay my parking tickets on time, or I, what makes a person irresponsible? And the government, to our advantage, clarified that irresponsible means dangerous. And stemming from that, dangerous means violent. So if you're violent, you may not be protected. And Mr. Rahimi was clearly a violent person. But the fact that the government is conceding that irresponsible doesn't mean, you didn't wash your dishes or make your bed or, have a parking ticket, doesn't mean that you're not protected by the terms of the Second Amendment. So that's a positive development.
Someone who didn't listen to the oral argument would think that you're making obscure references, but you're not. I mean, the justice actually, one of the examples he used is, I didn't take my trash can out to the curb on Thursday morning like I'm supposed to. So he was actually using the same kinds of analogies to what does irresponsible mean. They brought up at one point, you brought up something interesting. At one point, Justice Jackson asked the Solicitor General if there were some changes that she would advise the court to make to clarify the test in Bruin. And she gave a laundry list of all the things that the government wants to sort of take Bruin and make it very broad and very open. Right. And she wanted to have all these, she wanted to go back to she wanted to make it more general. So it was easier for the government to find analogies or analogous laws. It was easier for them to look into the various kinds of obscure little regulations or laws in the past. That didn't seem to sit well with all of the justices, but it seemed to be the direction
Thank God, because that is a briar patch, a quagmire, a mud hole that we do not want to have every Second Amendment case thrown in, where judges they're not looking at whether or not there's a law that was in place back then that regulated something similarly. They're looking at whether or not there was a policy or a practice or this is how people thought about it, even though they never put it on paper. That's not, if that's what we have to deal with, then Bruin, is
well, it means nothing
destroyed.
At that point. Right. It means nothing. Yeah. And so she was going into surety laws and she was going into surety laws and all this other
that's not to say that the surety laws may be indicative of the way we historically have designated and disarmed dangerous people. That's one way we did it. And then there were also specific, specific people who were disarmed based on different things they did. Now, so if the test becomes, so there was never a specific law historically that said domestic violence, people who commit domestic violence can't own guns. but there was laws that said people who do violent things can't own guns. And that I don't have too much of a problem with. If the court wants to say, look, a historical law that is not directly addressed to domestic violence, but is addressed to violence more generally, and in this case, the government is now saying domestic violence is a part of that general violence category, that's not as problematic as saying that some policy or some practice or tradition or concept that may have existed by some folks after the Bill of Rights was signed it means that that's a historical analog. That's what the government was pushing for. And also that the legislature, in its wisdom or lack thereof, can designate certain people as dangerous and classify them all, like every marijuana user, you're dangerous. And that's what the Biden administration said in one of the other briefs on the other cases. And that's important to keep in mind, by the way. There are at least 2 other cases, one of which is Range, which found a guy. Before I get to that, let me explain something. So when you challenge the constitutionality of a law generally, you can challenge it on its face, or you can challenge it as applied to you or to your client. So in this case, this was a facial challenge. Now, the problem with a facial challenge is that generally it has to be unconstitutional in all applications. So what I saw the Supreme Court doing yesterday was really narrowing the issues in this case. There was also all these due process issues about whether or not somebody can be disarmed without a notice and a hearing and an opportunity to be heard and cross-examine witnesses and all that stuff. And Gorsuch got in there and said, we don't need to deal with any of that right now, right? This is just facial challenge. And the question is narrow, is it unconstitutional in all of its applications? So that's a great sign that they're narrowing it down. Then he says, we don't have to deal with due process. They're narrowing it down more. We don't have to deal with Commerce Clause. None of that stuff was raised.
So is that okay? So for the layperson, Chuck, as I watched him do that, it started to worry me because I thought, well, really, I mean, I'm thinking about red flag laws and similar things, and that's a due process issue. But you're saying that no, his narrowing that down and jettisoning those things for the moment was a good thing. Can you explain to the average Joe like me why? Why is that a good thing? Why is it a good thing?
Because they want to uphold this law, but they don't want to be pronouncing broad principles about any of these other topics. Second Amendment is a different legal issue from due process, and they're all different issues from like a Commerce Clause challenge or vagueness challenge or whatever. They're all different, and so we don't want a big due process analysis in this case right now. We just want to have, and I think what the court's going to do is say this law is constitutional on its face. It's not unconstitutional in every application. It's constitutional on its face. So we're going to overturn the Ninth Circuit because we find that there is a historical analog to disarming violent people. And so to the extent that that's what this law does, sometimes it's constitutional. That would be good.
Does that then leave them open to go back and pick little pieces of it later on that are not unconstitutional? Is that what that does?
And the one that's probably going to come along next is Range, where a guy had a felony conviction because he didn't mention, $500 worth of lawn mowing money on his application for, I think it was welfare. So he was convicted of welfare fraud. Well, that is not a violent felon. And it was a long time ago. That is not a violent felon, and that is not the kind of thing. So as applied to him, the part of 922G that deals with felony convictions, remember there's 8 or 9 different types of people. Rahimi was domestic violence restraining order. There's felons, there's drug users. So the felons question is, as applied to Mr. Range, is that law constitutional? And that's going to be a much better opportunity for the Supreme Court to say, no, you can't apply it because it's an as-applied challenge. You can't apply it across the board. As far as this guy's concerned, he is not a violent felon, and and it's the violence again that we're going after, not just a broad class of people who didn't put their trash out or are.
Does this explain why the justices
or whatever other?
Yeah, and the justices, some of them, Gorsuch and and the Chief Justice in particular, seem to dig into this whole concept of dangerousness and what does dangerousness mean? Because it didn't seem like the general wanted to. She didn't really want to get into the definition of dangerousness. She was happy to leave that fairly broad.
Well, she made a big concession.
Did she? Okay. So, in fact, I was going to say, in fact, Gorsuch asked her at one point, do we need to really decide this section of the law that deals with the very thing you're talking about, people who aren't necessarily dangerous? And she, because he mentioned, I think he mentioned range, or mentioned the fact that there are cases heading their way. And she said, actually, yes, you do need to address that unless you want to see me back here again. So she was kind of hoping that they would, sounds like she's hoping that they'll settle this on a very broad basis, but they don't tend to do that.
They're going to look. They don't want to water down Bruin. Sotomayor wants to water down Bruin, and some of the liberal judges want to water down Bruin, and that's why they're talking about what can we do to help clarify this for the lower district courts. Well, that's great, or the lower courts of appeal. That's great. We need clarification, but the clarification that we need is that the first question is not a test. All arms are covered by all bearable arms are covered by the text of the Second Amendment, and then you get into the historical analogs. And what the government was also urging is that you get this loosey-goosey historical analog. Anything in history can justify a modern day law. I think if we get some guidance that says, no, you can't, it has to be this, that, and that before you can use it as an analog, that's going to be helpful too. And that's what I heard coming from Alito and Thomas and those folks. I think they're going to be able to walk this line, uphold the constitutionality of this statute, but not water down Bruin, and maybe even tighten Bruin up. Now, there's been a lot of media coverage, very simplistic media coverage, that made it look like this was a big win for the Justice Department, but I don't think so, because this law is still subject to as-applied challenges. If you have some kind of domestic violence restraining order against you that you didn't get a chance to oppose, or that you wasn't warranted, or something like that. But when it comes to marijuana users or nonviolent felons, I don't think any of that is going to be foreclosed. Challenges to those are going to be foreclosed by the ruling in Rahimi. And so to the extent that the ruling clarifies that first question is not a test, and that all arms are covered, and then it's a matter of going to the historical analog. And if to the extent they clarify that a historical analog has to be a statute or a regulation, not just some pie in the sky concept about what some guy was thinking one day about gun rights, then that will help too. So the problem has been in all the cases so far that the methodology that Bruin laid out has been distorted by the government, the lawyers for the states, and some courts or some judges, progressive judges, have bought into it. And so if they get straightened out in this case, even if they uphold the constitutionality of this law on its face, that's a win for us. That's a win for challenges to magazine capacity, semi-autos, all the different, emotion-laden buzzwords they come up with to demonize subclasses of firearms. That'll be a win. So I don't think that argument went badly at all. And the fact that they're trying to keep it very, very tight and narrow and limited is a good sign that all our other challenges are still well-founded. They're still viable. They are, we're right.
I found it interesting. It kind of points to the desperation of the government a little bit, that the Solicitor General said during her argument, because she was asked about them, the old laws that banned possession by Native Americans, that banned possession by freed slaves and that kind of stuff. Why was she not relying on those? And she said, well, now we're not relying on them here because we don't really feel like we need to. But she didn't disavow those laws, and she didn't make any indication that they wouldn't try to rely upon them at a later date. In fact, she said there might be reasons why they would. What astounds me is to me, that points to a level of desperation when you want to use these arguably despicable racist laws from our past to support your case. You can't. You got to be grasping for straws. Am I the only one that sees that?
No, that's been brought up in a lot of different cases. The government has this Hobson's choice where they either rely on racist laws as a historical analog, or they don't use them and then risk not having an historical analog. But I think that was probably they probably had a conference room discussion about whether or not to rely on those, and ultimately the government said, let's not go there. But I got to say, the Solicitor General, she did a good job. I mean, she's
a sharp cookie, I thought. She was pretty sharp. Yeah.
Yeah, she's smart. But she was asking for stuff that I know that Thomas and Alito and probably Gorsuch and Kavanaugh and Conan Barrett, because she had a great dissent in the Cantor case where she said, you can't get away with some of this stuff. They're rolling their eyes. They're going, no, you want us to interpret. You want us to water down. They know what the game's afoot here. They're trying to water down Bruin. Pull the Second Amendment is liberty's teeth, and they want to pull those teeth. So the Second Amendment is toothless, and nothing is protected.
So if you were a betting man, if you were an odds maker in Vegas, if you were that guy that people went to and said, how should I place my money on this? Where do you think this ends up in June or whenever we get a decision out of them? What do you think they're going to do? See, I'm asking you, every time you come on my show, brother, I ask you to prognosticate. I'm doing it again today. Right.
I need my Carmack hat.
Absolutely.
For those Johnny Carson viewers.
That's right, the great Carmack.
Well, let me make one other thing that we could get a good thing.
Now, before you do anything, I want to tell you what. You know what? If I get your home address, I'm going to get your home address, and I'm going to send you a turban. Just so you can be the great Carmack on my show. Anyway, I'm sorry. Go ahead. I wanted to know what you had to say.
I will put that right next to my Judge Benitez prayer candle.
Absolutely. You have a Judge Benitez prayer candle. I need one of those. I love it. That's great stuff. All right. So where do you think we're going to end up?
Okay. So wait. The point I want to make, we're looking for the silver lining here. Those racist laws are pretty much after 1791. And one of the other issues that's a big fight going on about is when is the appropriate time to look for those analog laws? And the states have been trying to argue that after the 14th Amendment was passed, that's appropriate time too, and even later than that. So Bruin and Heller both say, no, it's around 1791. There might be something after that that indicates what their intention was back then, but you can't change the intention from 1791 by looking at something that was passed in 1865 or whatever. So if they narrow down the appropriate time to look at analog laws, that's another win for us. So my great Carmack prediction is they will strike this law down, or they will strike the opinion, the lower court, the Fifth Circuit opinion, they will overturn it. They will say that as far as a facial challenge goes to this law is constitutional. We're not addressing due process. Due process could be another way to challenge this law, when you lose your rights without having an opportunity to try and fight to keep them. And so the fight, the fight is not over. And then they will take the range case and they will address the as-applied challenge in the range case with the guy who is a felon because he didn't disclose $500 worth of income. And they'll use that as an opportunity to really make some more points about how broad these laws can go. But they will also clarify that the text question is not a test. They will clarify. And the part that I'm a little nervous about is how loosey-goosey they get with those analogies, historical analogies. And they will clarify the time period that a analog law can come from to be actually relevant in determining the intentions of the founders in 1791. So that's all. I think that's a win. I think, I mean,
you're a little concerned about the loosey-goosiness of the analogies. What do you think the risk is there?
I don't think Thomas or I don't think any of the conservative justices are going to let Sotomayor or the liberal judges get away with it. They're not going to. There'll be a dissent probably, but that's not going to be the ruling of the court. They know that the state is trying to turn this into a free-for-all where everything is constitutional, anything they want to ban. But if they go even further, and say some things like every bearable arm is an arm covered by the Second Amendment. Well, that is going to be, the first thing we argue in the semi-auto cases and the magazine cases. So there's a lot of good that could come out of this to use in other cases, because the states have been abusing and twisting the Bruin analysis so much, and some progressive judges have been letting them get away with it.
Hang tight. We'll be right back to talk to Chuck more in a minute. This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. All right, back to the interview. Now, if they do exactly what you said, they find that the lower court was incorrect, they throw that out, and they decide that, nope, Rahimi, that dude shouldn't have a gun, and that law is constitutional on its face. I would take that as a non-lawyer and go, crud, we lost another one. But what I didn't see was that in doing that, it's sort of a secret squirrel way of saying, yeah, in general, it's constitutional, but you're welcome to bring us other specific challenges in specific areas, and we'll look at that. So they're actually leaving it open to be challenged in specific ways, where the guy who happens to get popped for smoking marijuana doesn't get robbed of his rights, or the fellow who forgot to disclose, or maybe did it intentionally, I don't know, but he didn't disclose $500 of income. That's absurd that now he's lost his rights over that.
Yeah, in the domestic violence restraining order context, the abuse is in the due process. You don't even necessarily get notice that this order has been issued against you. It's misused by family lawyers all the time to get leverage in a divorce proceeding. That and all that stuff is still on the table. But we don't want that resolved right now while we're trying to just dodge a bullet that could have come from Rahimi. So, by the way, one other thing for folks who are thinking, why aren't we rushing all these other cases to the Supreme Court? At this point, the Supreme Court session runs from October to June, but if they have a cert petition comes in January, or gets to a conference in front of the judges have a conference to decide whether to take the case after January. If they vote to take the case, basically, it's not coming before that court until the next session, the next October. So even if we tried to get another case to the Supreme Court right now, like Duncan or the Illinois case or whatever else, it wouldn't be heard until October next year. And under those circumstances, it's probably not. I mean, the consensus is we may as well go through the en banc process because it's not. We're one way or the other. We're still not going to be heard at the Supreme Court till next year. So I know it takes. I feel everybody's pain, and believe me, I really feel the pain myself with these delays. But Rahimi may clarify some. I think it will clarify some things to our advantage.
All right. So at this point, we've had Bruin, we've had Heller, Gaetano, Bruin. I mean, and McDonald, not necessarily in that order, and we're. Now, particularly the states and even the Biden administration, is throwing everything at us from soup to nuts. And it can kind of look kind of painful sometimes, and you feel like, good night, they're fighting with our money and we're having to come up with money to fight them back. But if you give us some hope here, where do you think we stand in this fight right now? On an overall basis, because this is going on across the country. It's not just in California.
Well, we just got to hope that none of the conservative judges get replaced by liberal judges, and that's going to happen after Biden gets reelected, if that happens, and or some Democrat steps in when he can't. He decides he's going to withdraw his reelection bid, and Gavin Newsom will drop in. If they get a chance to stack the Supreme Court, then that's what's going to change our game. But in the meantime, we got a solid 5, maybe even 6 judge majority that doesn't want to see Bruin watered down. So, by the way, let's not forget, we have the ATF, administrative proclamations. We told you this was legal before, but we changed our mind. Right. So all you guys who bought this based on us telling you that it was legal, well, you're all criminals.
Right.
That's not Second Amendment. That's administrative law. That's whether or not an executive agency can change its policy and pass some regulation that says something that used to be legal is now illegal. And we just got another ruling from a district court judge yesterday that invalidated the ATF, because the ATF, this is a form of entrapment. You know, if the government says, "Oh, it's okay to drive drunk," go ahead, and then they arrest you for it because they changed their mind. That's entrapment, and that's what's happened to a lot of people who had these accessories or bump stocks or pistol braces or whatever that were told they were perfectly legal to possess, and now all of a sudden they're felons overnight. This is the most frustrating and actually part of the way the government approaches this thing that angers me the most, is that they don't care about that collateral damage. They're like, that's a small price to pay for a whole bunch of people to become felons overnight. If it advances our agenda to take away civilian firearms ownership, so that civilian firearms ownership is not in the way of our moving towards whatever social engineering goals we have, that advocate big government and no individualism and
so you bring that up, and that's said a lot, and I've said it a lot. Some people poo-poo that fear, and they say, you guys are just being dramatic. I mean, how real do you think that actually is? How real is it that the government wants to take away our Second Amendment rights because they'd like to have more control and less fear of our reprisal?
Oh, I have absolutely no doubt. And this is from 30 years of, they know better than to say it out loud, but they say it behind closed doors. They say it in elevators. I mean, they say it in the halls of the capitals. This is sort of an open secret plus it's just common sense. This has been historically, this is what always happens when a tyrannical government arises, including, by the way, the United States. That's what Concord was all about. The government wants to take away the guns so that they can make you do what they want you to do. And if they want you to do stuff you don't want to do and you don't have a firearm, then they're going to be able to make you do it. So it's not here yet. Don't get me wrong. We're not at anywhere near that point yet. But at a certain point, if some of these slick politicians get in there and they give free stuff to a bunch of people to get them to vote for them, and then they start doing stuff that we never thought in a million years was part of our lives as Americans, the guys who are pushing that agenda know that ultimately it may come down to, another, I don't want to say another revolution, but some kind of armed resistance. And they don't want to have that. They don't want us to have, they don't want people, freedom-loving people who don't want to be led by a tyrannical government, to have that option of armed resistance. That's clearly part of their agenda. And so that's why you see every time they pass, it's all incremental. They pass an assault weapon law, they say, okay, you got to register them, then they invalidate the registration, and then it becomes confiscation, and then the assault weapon goes from an AR-15 to every semi-automatic that exists. Then they ban all semi-autos. Then they take out, it's a war on the gun culture. It's culture side. That is their goal. They want to wipe out gun shows, which we just got a great win on that one. Make it impossible to have a gun store. All of this is designed to just compact the armed populace. Now, fortunately, we've had, thanks to COVID and civil unrest in other contexts, we've had a lot of people stack it up. So it's going to be harder and harder as there's more and more guns. But that's definitely part of the ultimate agenda, a necessary part, and always has been historically in every country where a tyrannical form of government took over. And I don't mean to, say that we're anywhere near that level of tyranny, but
Well, the idea, yeah, the idea is to prevent that by not letting it get there in the first place. And I think that's sometimes people want to close the barn door after the horses get loose. And the problem is if the horses get loose in this instance, there's no closing the barn door. If all the guns are taken away, there's no way. Once you've lost that freedom, you're not getting it back. And the First Amendment is the same way. You know, there's two things that you brought up. I think one is you brought up, just kind of a legal argument I'll ask you in just a minute because I think it's kind of interesting. But the other is the fact that our rights are being assailed all the time. How important in your mind, I mean, you take your lawyer hat off and put your CRPA president hat on if you want. How important are things like X, you know, Elon Musk's effort there? How important are things like Rumble and these things where I'm on YouTube and they'll periodically, they may not delete a video. They do once in a while, but more often than not, they'll shadow ban the crap out of it. And the same thing happens on Facebook. They've deleted videos and shadow banned the crap out of it, but that has not happened to me on X. It has happened to me on Twitter, but it happened to me prior to Elon buying that thing. And it's never happened to me on Rumble, by the way. They've never approached me about anything. And so I'm wondering, from the standpoint of getting the word out for CRPA, for example, how important are those alternative platforms? And where do you see the importance of those going forward? I'm sorry?
They're the modern day town square. You know, folks used to get together and have a guy, a town crier, reading about what was going on, or you'd get the Benjamin Franklin's Poor Richard's Almanac, or whatever other thing he was printing up at the time. That's how they spread the word, and plenty of meetings in pubs too, where they talked about that stuff. That was the old way that it happened. But now social media is the public forum, and that's the other thing that the big government advocates know. If they can control the message, they can control the mind, and if they can, and a lot of people, sadly, are not as engaged. And I understand some of this. You got a job you got to do every day, and kids you got to raise, and there's life gets in the way of advocacy sometimes, and being fully informed. But that's why, I am comforted every day as I look at my X feed and my Instagram feed and my Facebook feed and all this other Google, Twitter, Face stuff that I got to try and keep track of. I follow the folks that understand the issue, and I see a lot of information out there. Now, is it as widespread as it could be if it wasn't being muzzled by some of these forums? No, but you're right. X, thanks to Elon Musk, and some of the things that he has exposed from taking that over and having access to all that information, and there's congressional hearings on this, and I see a lot of this on X, where they're talking about what Twitter did, how they worked with the FBI to censor messages that made the Bidens look bad or made the Democrats look bad or whatever it was. There was all this censorship. But that, by the way, that's another tool of a tyrannical government to try and control that flow of information. That's nothing new. The control of the press. Communist countries, you can't say whatever you want. And that's deliberate.
Well, we see that even in non-communist countries. People are being arrested in the UK because they have an opinion or because they stand outside and they have an opinion that isn't the opinion du jour at the moment. And so it's politically unliked. You mentioned something else I thought was interesting, too, and that was that one of the cases we talked about, you said, was not a Second Amendment challenge. How many of these and how often do these come up where they affect the Second Amendment, but they aren't necessarily, you don't necessarily take them to court and challenge them on a Second Amendment basis? This comes up once in a while where I'll have people contact me and go, well, how come they're not bringing up the Second Amendment on this? And a lot of times it seems to me that maybe the challenge affects the Second Amendment, but it's not the most strategic way to go and fight it. Do you find that you're fighting other types of things, First Amendment battles and those kind of things that apply to the Second Amendment?
Yeah, it's the Second Amendment. I don't know. I would imagine that it's some of those ATF cases challenging the ATF's
That's what we were talking about. You said it was a process issue, right?
Yeah, it's an executive agency just has to adopt regulations it's part of the Administrative Procedures Act. You have to do it a certain way, and taking a position contrary to an earlier position, you can't just do that unilaterally. The law basically has the underlying statute that the agency is interpreting has to change before the agency can say, well, the way we read that law before is not the way we read the law now. That's administrative procedure law. That's regulatory authority law. Now, I'm sure that in some of those cases they made Second Amendment claims too, but the primary issue is whether or not the ATF exceeded its regulatory authority. DOJ in California does that. The Illinois State Police in Illinois is already starting to do that. That's very typical for an administrative agency, a politicized administrative agency or law enforcement agency, to try and do that, change their policy because they don't like the way people figured out how to comply with it, or people that they didn't think would be able to do something they didn't want them to do have now found a way to do it. I mean, but there's a lot of different tangential sort of side attacks. Like I mentioned, due process, whether a statute is vague, that's not a Second Amendment argument. That's a due process constitutional argument based on due process. Trying to think of some other examples, but you mentioned the First Amendment. That's the gun show case that we just won, where they were trying to stifle that speech. And so we use the First Amendment to attack and protect the Second Amendment, to attack the law that strikes at the Second Amendment, even though, but we made a Second Amendment challenge too, which we also won on. But yeah, you're right. There's a lot of different, it's not just Second Amendment.
It's a more complex thing than I realize it is as a layperson. I got to tell you, it's very complex.
This is why I would not argue a Second Amendment case in the Supreme Court, because all those nine robes do all day. They sit around and they figure, and they're not just doing Second Amendment cases. They do every type of constitutional law case there is. And they have a big picture in their minds about this huge seamless web of constitutional law. And you can't just parachute in and take a narrow Second Amendment case and assume that that's all that's going to be discussed. Other constitutional doctrines can get dropped in your lap in a Supreme Court argument, and if you don't know it all, if you don't practice all those different fields, you can get blindsided and lose your primary challenge because you didn't see this flanking maneuver coming around from another area of law. So you got to get a lawyer. The lawyers who do the constitutional arguments in front of the Supreme Court have to know all these fields and be pretty experienced in all of these fields in order to do a good job.
Well, this explains why the public defender that argued in Rahimi for Mr. Rahimi he struggled in some areas and he got beat up a little bit because he's not as experienced. I don't know if that was a trial public defender that was doing that. I got to think. I mean, I don't know if the public defender's office. But most law firms, it's not a lateral progression. You don't get the case at trial, try the case, lose, take the case on appeal, win or lose, take the case up to the Supreme Court. It's not the same lawyer all the way up and down usually. I don't know if the federal public defender's office, you bring in my office, I have a couple lawyers who are appellate specialists, and I got trial specialists, and I got, depending on what procedural stage of the case you're at, different lawyers may come in to get involved in at different levels. Crazy. Well, Chuck, thank you very much. This helps a ton. I mean, it helps to understand the case, but it also helps to understand the battle, because when you're just I'm a firearms instructor and a business owner, what do I know? Or you get the guy who's the plumber or even the doctor or whatever. This stuff can get lost on us because it's not the world in which we live. So I'm grateful that you come on and explain a little bit of the inside baseball stuff as well. Helps a ton. Is there anything we haven't talked about? Something that we should touch on before we go?
Oh, well, we got a bunch of other cases going on, but have me back another time. We'll talk about.
Yeah, it would be 3 hours. Yeah. I will do it. Thank you, my friend.
And it is. Government will win, but it will be a perfect victory. It will be a victory in name only, and the process for challenging laws under the Second Amendment is going to be strengthened
So you said, okay, so wait a minute, because you broke up a little bit. You said the government will win in the Rahimi case, but it came out as a perfect victory. I think you meant to say it's going to be an imperfect victory. Is that correct?
I was trying to say horrific, which I think is that a word? I might be getting that wrong.
I don't know. Well, anyway.
Is it symbolic? A symbolic victory, okay. A victory that doesn't really mean anything. So
don't freak out.
We will be the real winners. Yeah.
Okay, no freaking out allowed. This is not a freak out zone. Chuck, thank you very much. Have a great week, brother.
I got to go look up horrific now and make sure I'm using it.
Text me and let me know.
It's always good. I'm going to light a candle for you, brother. I think I know what your Christmas present's going to be. So,
yeah. Well, yours is going to be a turban, so you can play the great Karnak. I'll see you later. Take care.
Okay, pal.
Thank you very much for watching the entire interview. I'm super grateful when you do that. I find this sort of, back alley, backdoor, I guess, inside baseball look at things once in a while kind of revealing. Helps me keep from being frustrated. I hope it helps you, too, to understand a little bit about what's going on in the courtrooms and why. We are winning, and I'm grateful for that. It may not always look that way, sometimes a little deceiving, but we are getting win after win. So stay in the fight and don't give up, and keep supporting the organizations that are helping you to save your Second Amendment rights that have been taken from you, and restore them and make sure that they're safe for the next generation. If you'd like to help me out on Gun Guy TV, you can do that by joining Gun Guy TV Crew. It's available on both Locals and Patreon. Hopefully, at some point, it'll be available on X as well. Not so far, but I'm working on it. It's very inexpensive, but it allows you access to me and also access to some content that I produce that's exclusive to Gun Guy TV Crew, and you can't get it anywhere else. Once again, have a great week. Thank you so much for all of your support. And wherever you go, whatever you do, stay safe.